Sorry, I'm not trying to throw you off here. I'm not trying to pretend I'm a Supreme Court justice that's jumping in and throwing questions at you. But I would note that the slide that you have. Good afternoon. Thank you, everybody. Please have a seat.
Good afternoon.
Let's go ahead and have you state your appearances. Do we have a calendar page, please?
I don't.
I don't have it. It's okay. Just to make my notes. Go ahead and state your appearances, please.
Good afternoon, Your Honor. Randall Jones on behalf of the state.
Thank you.
Good afternoon, Your Honor. Michael Gain, also on behalf of the state. And I normally introduce the folks on Zoom, but I can't see them. So we do have a number of people who will just be observing on behalf of the state.
And that's fine. No need to introduce the folks who are just observing. They're welcome to observe, and we noted that before we came in that there were a number of observers. So.
Good afternoon, Your Honor. Davidson on behalf of the state.
Good afternoon. And we'll come over to the other side. Mr. Fugazzi?
Yeah, good afternoon, Your Honor. Alex Fugazzi on behalf of defendant Snap, and with me I have Ms. Jessica Davidson and Jonathan Blavin, both of whom have been admitted pro hoc leadership request.
Yeah, I tried to get to those pro hocs right away so that everybody could be here to be present. And is there anybody else to make note of for the record before we get started?
Your Honor, Phil Carlson on behalf of the state.
Yes, thank
Pro
you.
Hi, Your Honor. Mark Kruger on behalf of the state.
Good afternoon, Your Honor. Raquel Fulgham on behalf of the state.
Good to see everyone. Sorry you're sort of relegated back there. We sort of ran out of chairs. If you wanted to be closer, we could probably pull some chairs around. If you're good there, we can proceed.
We're fine. Thank
All
you.
right, thank you. This is the date and time set for the hearing on the Snap Inc.'s motion to dismiss. I'm going to be very candid out of the gate on this. I do not intend to render my decision today. I intend to get the fullness of the argument that you wish to put forward today. There are a number of moving parts obviously here in terms of the bases for the request for dismissal. At its heart, it's still a motion to dismiss, and it still all boils back to the standard of are there claims that, if proof could support them, could indicate that plaintiff would be entitled to relief here. There's a number of bases upon which it's argued, including lack of jurisdiction, et cetera, that perhaps the state is not eligible to go forward with one or more of its claims. And we're going to take full argument, and then the court will likely set a future court date to return for the decision. Now, a couple of things, just housekeeping, just to get started. There were two notices of supplemental authorities. There was a concern expressed in response to the first supplemental authority notice that there had not been a motion made to seek that consideration by the court. The second notice did come in connection with a notice and a request for the relief for that to court to take notice of that case as well. I'm going to, for purposes of today, because I think it is important that we ensure that we have reviewed everything that may be relevant case-wise, what's been put before the court, obviously, not only by the state to indicate prior motions to dismiss that have been denied, but what has been put forward by the by SNAP to point to other jurisdictions wherein injunctive relief may have been granted related to a particular state statute that may speak to the First Amendment arguments here. I'm gonna consider it all. Okay, so I'm not going to deny the ability for the notices to have been filed and for those authorities to be reviewed. I will have, and I have in fact reviewed those authorities coming into today. So I wanted to dispose of that. I'll let you speak in the argument with regard to the, how was it phrased, conditional counter motion for purposes of possibly doing discovery on the jurisdiction issue. I just want to hear full argument today. If it is something that is determined that is needed, then again, upon the court's issuing its decision, that would be addressed at that time. So again, fullness of the argument that you wish to address. Obviously the briefings were very thorough, very detailed, always appreciating the efforts that the council go to put these things before the court in a meaningful, substantive way, and we certainly have that. But oral argument is equally vitally important in the court's opinion to ensure that we are connecting to all of the arguments that are being put forward, not misapprehending some arguments, not misconstruing any facts that may be addressed. Again, all dialing back to this is motion to dismiss. This is not a situation where the court can or will ever weigh evidence. This is a situation where we have to look at the face of the complaint and ultimately determine are the claims, any one or more of them, viable to continue through and survive dismissal, or are any one or more of them in some way barred or precluded from being pursued this time? So that's the only setup I'm gonna give. I'm not gonna try to give you my, sometimes, which I do, sort of summary of how I see the arguments lining up. I'll just let you all take care of that as we proceed. I understand perhaps that you wish to divide up the argument. Is that correct, Mr. Fugazzi?
It is, Your Honor. Ms. Davidson, Mr. Blavin, there's really three sets of arguments, and each of them are respectful of the court's time. We're not going to be speaking over one another or duplicating efforts, but the request is that you would let them divide the argument.
And that's fine. Is there any objection from the state side?
Well, Your Honor, certainly in terms of what is anticipated, at least in my experience, and what is the norm, is that if you file one motion, you have one person speak to that. And so, yeah, I think that is certainly we could have done the same thing. We didn't nobody reached out to us and asked me about that before today. And I'll be candid with the court, I objected yesterday. We had our motion to dismiss in the TikTok litigation from Judge Kitchener yesterday. And they asked, TikTok asked me to be able to do that. Again, I did not agree to that, but Judge Kitchener allowed that, but over my objection. And I just think it's an unfair advantage to have multiple parties arguing a motion if it's all contained in one motion. And that is, as I understand it, the standard practice in this jurisdiction and this, in the Judicial District Court. So, you know, the court obviously has the full authority to do what it sees fit about that, but I think that is improper and I would object.
It begs the question as I come back to you, Mr. Fugazzi. Why would we not have communicated with the opposing counsel and given the opposing counsel the courtesy of knowing that that would be the request and the opportunity perhaps to do something similar?
Your Honor, it's a fair point. The simple reason is I didn't think of this as a strategic advantage. If there is one, I've worked with Mr. Jones for years on cases. I am not a sandbagger type of lawyer. I don't see the strategic advantage. Both sides have armies of lawyers working these cases, as you can see from attendance here and on the screen. I think there's not one side overlawing or underlawing another. There's no advantage to it. And we would have no objection to the state having more than one person argue. And going forward, if this is a issue, I'd be happy to give notice in advance. But the last thing I would say, Your Honor, my experience is a little different. On simple motion practice, I agree, it's usually a one lawyer, one argument issue. But cases of this volume, this magnitude, quite often have more than one lawyer arguing. I don't think that's a surprise to anyone.
So I would just respond.
Final word.
Yes, by the way, I agree. Ms. Daisy is not just a colleague, somebody I consider a friend. I don't think it was any untoward action here, but the reality is, it is prejudicial because I have been in cases where there's been multiple issues in a motion that was filed as a single motion, and multiple lawyers have argued different aspects of it. But that was by agreement of the parties, where both sides knew that was going to happen, and we could prepare for it. There's a lot of material here, Judge.
Yes.
So I had to go and study all of this, and there are other very capable lawyers on our team that I would have split it up with had I known we could do that or were going to do that. So I absolutely disagree. There is an advantage to having limited segments of this motion that has got probably 8 or 9 different moving parts. So yeah, I believe there is prejudice. I believe that had they contacted me, I may or may not have agreed to it, but at least I would have known about it, and we could have made a strategic decision of our own to say, we're going to split it up ourselves.
What about from yesterday to today, given that that happened in the hearing yesterday, which I wasn't aware that the hearing had happened yesterday. I have not availed myself purposefully to see what is happening in Judge Kistner's case or with that consolidated matter over there. I know of its existence, obviously, but I chose to just prepare for this one and look at this one, and I wasn't aware that the hearing was yesterday or any outcome there, and you don't need to share that here today. But knowing yesterday that that's what the ask was and how it was divvied up, was that not anticipated, or was it just too late at that point to make an adjustment?
Well, it was, I actually kind of didn't anticipate it because in that case, Kobe Williams is local counsel for TikTok. And Kobe contacted me on Friday last week and said, hey, I want to do this, and we talked about it. So he did give me advance notice, and I said at that time, I didn't want to do that. And I didn't know that Judge Kishner was going to allow it, because my experience has been, unless it's agreed to, it's not allowed. But at least in that case, I was prepared for it. And I do believe, by the way, that it was a disadvantage to us, although I'm not unhappy with the outcome, that's all I will say about that. I do believe that it was to the other side's advantage to have two lawyers arguing different aspects of the motion. So, again, you know, I'm prepared to do this. I leave it to the court's discretion, but based on my experience, I think it's improper and it's not appropriate under these circumstances.
I always like to be very practical, and this is how I would practically approach it. I am inclined to allow multiple counsel to be able to argue and highlight the various arguments. I saw it broken down more than 3 ways, so they said it's broken down 3 ways, so be it, we'll find out. But here's the alternative I can give you. And I'm not trying to be facetious here, because I appreciate it may not be a practical alternative given that people have traveled from out of state, et cetera. But one of the things that I would consider is moving the hearing to another date. I do not have a trial the rest of this week. I did not pick up a trial for next week. So we have flexibility, and giving you the opportunity to move it to another day and divvy up the argument if you wish. I'm open to that. Because I do think, while I'm not going to necessarily, as I sit here today, especially with the quality of the advocates that we have here to present today, and especially the 2 primary advocates that I'm familiar with, I'm not going to necessarily consider this disadvantageous or prejudicial, but at the same time, I think it's fair, since one side wishes to proceed that way and there wasn't communication in advance. I don't know of any rule that requires there to be agreement, but it certainly, to me, would be a fair ask to, if that is the ask, to come back on another day in which the arguments have been fully divvied up in the way each side sees fit. So.
No, not that my objection for matter, but no objection on the part of staff. If you'd like to do that, if plaintiff really believes it's an unfair advantage, we'll take another day on that.
Mr. Jones?
Well, depending on how you rule, Your Honor. With that said, all kidding aside, maybe if you would give us some latitude, because there are certain people, some of our colleagues at ProHoc are really have more specific expertise in certain areas of like Section 230 or whatever. So to the extent that they might want to add a comment or something, I don't know if the court would allow that. I get the tag team issue idea, but by the same token, I'm trying to be flexible here too and allow us to proceed and maybe give us a little latitude if the court thinks it's done.
So am I understanding you correctly that you want to proceed today, but if the other counsel wish to add to your argument, that they be given the opportunity to do that?
Correct.
I'm fine with that.
Okay.
Any objection to that?
No objection. No.
I'm fine with that. Let's plan to do that, and just as the way I gave myself some grace to be as prepared as I could be coming in here today, but recognizing that I was probably going to want to digest things and go over things, because I want to be sure I'm making my best decision. My best decision also is dependent on the oral argument that we receive to complement the written briefs. And so to the extent that each side wants to be able to put its best foot forward on those oral arguments, I am fine with that, and I appreciate that. So I'm gonna turn it over then. Who's gonna begin on behalf of SNAP?
Ms. Davidson is, and we have a few demonstrative slides that are on the screen. I also have a handout that may I approach the court and hand to counsel?
If council has a copy, certainly. This is by way of demonstrative, you indicating?
Yes, Your Honor.
Okay. Would you like to use the podium, Ms. Davidson?
Your Honor, may I approach?
You may.
Is that your preference, Your Honor?
No, I have no preference. You argue from wherever you are most comfortable. I just need you to be near a microphone to be sure that the recorder can pick you up. So it's entirely up to you.
We learned that it was picking us up as we were chatting.
Well, that's different than picking you up for a really solid record that down the road, if and when there's a transcript that needs to be made, we have it. So please proceed at your convenience.
Understood, Your Honor. Before I begin, I just wanted to explain that my colleague, Mr. Blavin, is very experienced with the Communications Decency Act and First Amendment issues, that's his specialty. I'm more of a product liability lawyer, I'm a mass tort lawyer, and that's the reason we split it up. It was not, I just wanted to be clear, it wasn't in terms of any trying to get any strategic advantage, it's basically what our areas of expertise are.
Understood, and like I said, I think we've already addressed it. One thing I guess I would add to complete this record is certainly, Mr. Jones is not wrong. The court's expectation would be when there's one motion, there's one attorney that's arguing it. The court previously had a lengthy tenure on the business court bench, does not currently preside over active business court cases, but still serves in some roles with business court and is very familiar with the larger, more complicated cases and the typical situation, a situation that could occur, I'm not saying typical, but a situation that could occur where the parties may wish to divvy up arguments amongst the various counsel. And it has been my experience that usually is done with the understanding from both sides that that is what they intend to do, and then the respectful ask made to the court. The communication didn't quite happen that way this time, but at the end of the day, I understand that. It still, though, potentially is advantageous for people with particular expertise to be able to dial in multiple arguments with their particular expertise, rather than whoever is the lead counsel having to be able to become familiar with and share that argument. So I do think that there is some advantage, but at the same time, I don't think it's a situation that, again, that's why I opened the door to the opportunity if the state wanted to take more time and divvy up the arguments, but we solved that problem with their request and no opposition to their request to have multiple people possibly ultimately respond in the end. So you may proceed, and I'd like to just jump right in and get to the heart of what it is that you'd like to highlight for the court, why you believe dismissal under the Nevada standard of what dismissal is applicable in this case for whichever part of the arguments you are focusing on and whichever claims. And because this is a dismissal ask, obviously we have the 6 claims in play in the complaint, and let's be precise. I don't want to just say, okay, here are our general arguments about these things. I want us to have a good, clean record. I am here to, for lack of a better word, attack claims such and such and such and such on these bases, and here's my argument.
Thank you, Your Honor. So basically, I was going to start with a brief discussion of personal jurisdiction, then Mr. Blavin was going to address the Section 230 and First Amendment arguments, and then I was going to address the claim-by-claim arguments. I'm starting with personal jurisdiction, obviously, because it's a threshold.
And that seems fine. Let me just inquire of Mr. Jones. As far as the state's response to the oral arguments, Mr. Jones, would you prefer to make your responses by subject so that we break within the subject? So when Ms. Davidson covers the jurisdiction, first and foremost, would you then like to respond at that time? Or would you like to have all of the arguments being made for all of the bases upon which they're seeking dismissal, and then you have your opportunity and colleagues' opportunity to speak to all of it?
I guess, Your Honor, I'd answer this way. Is there a time limit the court has today on parties?
Well, we have to leave at 5.
Okay, so you answered my question. I think I would rather just, let's go and see where it goes, and then I would get my opportunity to respond to all the issues, and then they would have rebuttal.
That's fine. I'm fine with that. The only reason I ask is, depending on how lengthy each argument is, and each argument is very sort of divided, if you will, or at least maybe compartmentalized or can be compartmentalized in some way, on one hand, the record could be neater and cleaner where we have each topics argued by both sides. But on the other hand, I have no problem following the usual process, which is you'll make your arguments, divide it up as you see fit, and then the state will make their arguments.
Your Honor, let me maybe get a clarification. I understood there were 3 arguments that you're going to make, and what are the 3 arguments?
The 3 buckets
Yes.
are first personal jurisdiction,
Right.
then Section 230 and First Amendment issues, and then the claim-specific issues. In other words, claim by claim.
So they're gonna divvy it up with jurisdiction, the Section 230, and then basically go through all the claims. Because I was asking for the arguments to be when the time comes, but honestly, even with jurisdiction, okay, jurisdiction applies to all 6 claims, or this argument applies to these claims. I would just want to be specific in the arguments, but that's how they intended to divvy it up.
Yeah, I think, Your Honor, at this point, let's do the whole thing
All right.
and see where it goes.
Sounds good. Go ahead, Ms. Davidson, when you're ready.
Thank you, Your Honor. Your Honor, I'm guessing you have some familiarity with Snapchat. It's a communications platform that's downloaded.
I guess it would be a good point to make the record that I do not have an account or otherwise utilize the platform, but I am certainly through my job and through, personal conversations with others who utilize it and familiar with the platform.
Excellent, Your Honor. So I will not belabor you with a long discussion of it. I just want to make the point that Snapchat is a platform that is downloaded for free on a phone or another device. And there's no payment for it. And I think that's important for what I'm about to talk about, which is whether it is appropriate for the state AG to be suing in Nevada, or whether the state AG should be suing in California, where Snapchat is based, and where, right now, 33 other state attorneys general have claims pending against Meta. So, Your Honor, the Nevada Supreme Court has adopted the principles of personal jurisdiction as they have been established by the Supreme Court of the United States. And
Can I ask you this, and I'm sorry, I'm not trying to throw you off here, I'm not trying to pretend I'm a Supreme Court justice that's jumping in and throwing questions at you, but I would note that the slide that you have here goes specifically to evaluating specific personal jurisdiction. Are we in agreement that that is the focus on the jurisdictional question and that general jurisdiction is not in play? It appears to be from the briefings that has been conceded, but I just want to make that record so that we can jump right into specific.
Yes, Your Honor.
All right, thank you, Mr. Jones, go ahead. Ms.
Excellent,
Davidson.
Your Honor. So as you clearly are quite familiar with personal jurisdiction issues, I'll try not to waste too much of the court's time addressing the basics of it, but I think the Tri-Carici case is critical because that's where the Nevada Supreme Court really set forth the standard for determining whether there are appropriate contacts and whether there's purposeful availment by a defendant of the state. And the question here obviously is, does SNAP has it purposely availed itself of the privilege of acting in Nevada? And are the claims asserted by the AG sufficiently connected to whatever contacts SNAP has in the state?
And I would note that your reference to the Tri-Carici versus Cooperative Rabobank UA case, 135 Nevada 87, is displayed in your demonstrative, and I only make that record because if we're going to utilize case names, it is helpful for the record to also at least give the Nevada or Pacific Reporter citation and at least spell any names that might be problematic. But if they're all references are going to be coming from what is displayed here in court and on the demonstrative, that's fine. My recorder has that, but she doesn't necessarily access all the briefs, so it would be helpful as you're doing that to highlight those things.
So Your Honor, I did put all the cases I'm going to talk about right in the slides to make it easier.
Perfect, thank you.
For the most part, Your Honor, courts have recognized that social media or other online platform does not purposely avail itself of every single state where it has been used or downloaded. And so here what we have is SNAP is based in California. It has been downloaded in all 50 states. But the mere act of the downloading is not a purposeful availment of the state of Nevada. You need something more. You need something like SNAP coming into the state of Nevada and soliciting customers here. And those customers, or users is a better word, right, because it is a free app. And those users bringing some sort of claim that's related to what SNAP has done in the state. And we just don't have that here, right? What we have here is people are downloading an app, and there are third parties that advertise on that app. But SNAP has not done anything particular to the state of Nevada in this case. And so I want to...
So based on your argument, could there be specific jurisdiction anywhere other than where there's also general jurisdiction? Because I would think the case law would obviously recognize, and I think the court would be mindful that it can easily occur where an entity can have not general jurisdiction applicable to it in a given jurisdiction, but specific. But as I'm hearing your argument, it sounds like you're indicating that at least for SNAP and its business model, for lack of a better way to put it, only general jurisdiction locations could also be specific locations, or say it in reverse. Specific jurisdiction could only be had where also general jurisdiction could be had. Is that what you're arguing to the court?
So, Your Honor, I do think it's very fact-specific, right? What are the facts alleged in the complaint? Personal jurisdiction goes to the facts alleged in the complaint, and if we could move to the next, to slide 5. It's what are the facts alleged in the complaint, and whether they satisfy the Supreme Court test and the Tri-Commission test. And the reason I hesitate to answer your question is there could be a set of facts where I'm not aware of it, right? I don't know what SNAP's involvement is, in every state in this country. There could be a set of facts where SNAP has gone into a state and sought specifically to avail itself of the citizens of that state, and there is a lawsuit arising from that. So I don't know what, standing here, what that fact scenario might be, but I don't think that to rule in SNAP's favor here requires such a blanket ruling that it could never be subject to personal jurisdiction in any state but California. For this case, though, I think it's important to look at what's alleged in the complaint, right? And so the first allegation on personal jurisdiction is in complaint paragraph 88, where the state alleges that SNAP entered into hundreds of thousands of contracts with consumers in Nevada. And by contracts, what it's referring to is there's no sale, there's not a sales contract, nothing was sold or purchased. This is talking about when you go on a website and it gives you terms of use, right? Like every website you go on nowadays has terms of use, every app has terms of use. And so the problem with this allegation is it would mean that every website and every social media company would be subject to specific jurisdiction in every state. It's almost the reverse of what Your Honor was positing. Are you saying there will be no states? This would mean that every entity that's on the web would be subject to personal jurisdiction.
Wouldn't that be fact specific though to, are there actual users in that jurisdiction? Have they actually downloaded the app? Are you then ongoing having communications via the app with them, providing that platform for the advertising, whatever it may be? Wouldn't that be fact specific? So if those things exist, for instance, here in Nevada, then that's where that argument would lie, right?
So I think that's right, Your Honor, but the courts have really held that when you're talking, just because you have users in every single state, that's not enough. Your Honor raised something now, which is there some sort of back and forth with the company in the state? And that would be a different fact scenario. But what we just have here, right, is hundreds of thousands of consumers in Nevada, assuming, we're gonna take what the state says is true for purposes of this motion, downloading the app. And the courts have held that that's not enough. And we cite here on slides 3 and 4, a number of courts that have held, beginning with Jamie Crisostomo v. Hernandez, 2022, Westlaw, 205-27084, and let me know if I'm talking too quickly.
Since it's in the demonstrative, I'm just gonna check in with my recorder. We don't need it to be separately stated here. My point was, and I made the record the first time, is because if you had anything that wasn't in the demonstrative, then we would need you to do that, but since it's all here.
So here on slide,
Mr. Jones stood behind you.
I hate to object unless I have to, but since this apparently is a document that the court is going to have in the record, this last slide right before this one references a case called Ace American Insurance Company. And we just got these, as you saw, moments ago. So we're trying to check, but we can't find that this was ever cited in our briefs, and if not, then it would be an improper citation at this point to include this in the presentation as supporting
It's that
authority.
one, Counselor. Leave it there, please. Yep, bottom, third three.
Yes, that's correct. That's the last one. So to the extent the court is looking at these cases, and we would certainly object that the court, that they be considered under the circumstances. Again, we can't find a reference to them in the brief.
Can you point to where in the record, Ms. Davidson, that this case has been highlighted, if you will, or utilized in your briefing such that it makes it appropriate use in the demonstrative?
Your Honor, this is a case that I found as I was preparing for oral argument to address plaintiffs' claims in their opposition brief about trade shows, if that's improper under Nevada law to use a case that's not in the briefing, we can expunge it.
I've already indicated at the beginning of this hearing that I intend to return on a subsequent date to render a decision. And to the extent that there is anything here that the court either might have otherwise on its own connected to, or that you're bringing to the court's attention for purpose of argument today, there would be opportunity, obviously, for the state to respond if it was so inclined. So at this point, I'm gonna note but overrule the objection and allow you proceed. Are there other places though here, so that we don't have to do this each time, if you could let us know, Ms. Davidson, where you recently found something preparing for argument that is now in your demonstrative that's not in your briefing?
Yes, Your Honor.
Where's that?
Slide 12, which we're going to get to after Mr. Blavin speaks, which relates to Eden versus Desert Palace, is a case that I identified over the weekend.
And that was the only, at least so far, that's the only one we found, so I'm sorry about that, so we don't have to interrupt again in the argument. But
All right.
that is an additional one that we have so far found.
We will note the objection, and as I said, we'll let you go ahead and speak to these authorities that you have found and placed in your demonstrative. I'm going to make the demonstrative a Court's Exhibit 1 for purposes of the hearing today anyway, since we have it now, and there's obviously been some significant discussion about it. And I'm going to myself highlight in yellow the cases that were of note in the objection by the state as not having been, and then acknowledged by SNAP as not having been something that would previously have been noted or cited in a brief, but is coming up today for argument purposes.
And I would note, Your Honor, neither is a Nevada case. These were cases that have persuasive rationale in them, and that's why I included them here as I was thinking about these issues over the weekend.
Understood.
So
Anything else, Mr. Jones?
Just to be clear, how would you like us to respond to these new cases? In what form? I don't know what.
Well, I mean, can we deal with that after the fact, housekeeping wise? I don't know, you could do a supplemental brief, I could give you authority today for leave to do that. If you thought that it was necessary to speak to why you think these authorities don't support what they support, and we can pick a date for that. There may be other things that come up that you all, after we complete this argument here today, want a supplemental brief, and I'm not gonna necessarily mandate that, I don't see that happening, but in the end, if you want that opportunity, you can have it. So that would be my assumption, is some form of, response to, additional cases or something like that you would style it.
Thank you, that's just fine.
Okay. Thank you, Ms. Davidson.
Okay, thank you, Your Honor. Going back to where we were, I was indicating that on slides 3 and 4 are examples of cases where courts have held again and again that having a website or having a social media platform is not sufficient for purposeful availment. And that takes me to plaintiff's second theory on slide 5, which is advertisements. And what plaintiffs allege is that Nevada entities advertise on Snapchat to reach Nevadans. The issue with that is that the entities advertising, those are purposefully availing themselves. But that is very different from whether Snap is. The question for the court today is, what are Snap's contacts with Nevada, not what are the contacts of third-party advertisers? And that is, again, highlighted in the same cases on slides 3 and 4 in the Chrysostomo case and in Palmer v. Savoy, that you need to really ask yourself who's advertising and who's doing who's coming into the state and trying to avail itself of the forum. So the third theory that plaintiffs have included, and this was not in the complaint, it was only in plaintiff's opposition, but in the spirit of Your Honor making clear that you want to consider all the sides' arguments, I'm going to address it even though it wasn't in the complaint.
Okay.
And that's a list of various purported contacts that the state attached to its opposition brief in an affidavit. And they are examples of, there was a sports event at some point, a nationally reported sports event in Nevada once, and there was a sign for Snapchat at the sports event. I think it was the Super Bowl. There was
Just a little sports event.
I'm really unsporty, Your Honor. There were conferences there was a conference, a consumer electronics conference in Nevada, and Snap had a booth there. And I thought of this morning because the city, as you may know, is overrun by miners. I never knew there was such a huge mining industry in this country, but there are like hundreds of thousands, it seems like, of men in this town. It doesn't seem to be a very female-dominated field. People here for a mining convention. And there is probably, I'm guessing, in the convention center, tons of booths set up by every mining supply company in the world. Having those isolated booths at a convention certainly can't give rise to specific jurisdiction. If it did, there would be a specific jurisdiction for every company probably in the state, because you're very fortunate to be very attracted to conventions. And so everybody's having conventions here, and so it can't be that that's enough. And that relates to the case that I apologize, Your Honor, for not being sufficiently familiar with the rules of this court, that I did include it in the PowerPoint that I was looking for this weekend. Like, can an occasional trade show really be a purposeful contact? And that's why I thought this case was interesting. It was about a boat show, and how, being at a boat show or advertising at a boat show doesn't suffice to create jurisdiction because it's isolated. And so the examples that plaintiffs gave, and one of them was like a vending machine at a conference, those are the types of occasional rather than purposeful or continuing contact that don't give rise to specific jurisdiction. There's a second problem with this third theory as well, right? And if we go back, you'll remember from the Tricarici case, right? You have to ask, did the cause of action arise from that purposeful contact? And that's really important here too, because the state is not saying that somebody who attended the Super Bowl or somebody who attended the Consumer Electronics Conference at the Convention Center had an injury because of being exposed to a contact from Snap at that event.
So your specific argument related to that is it does come up obviously in the context of specific jurisdiction, that in order for the state to pursue their claims, it would have to be able to be tied that those contacts then resulted in people downloading the app, then suffered injury related to the downloading of the app. Is that a fair summary of your argument?
Well, I think yes, Your Honor. I think if the vending machine at the Consumer Electronics Conference fell on someone's head, then the vending machine being in Nevada was directly tied to that person's alleged injury. But
What about someone who downloads from the advertising, even if it was isolated, and then suffers the injury that the state alleges?
So the state here is alleging that teenagers, right, are downloading this app, and that teenagers are suffering non-specific types of mental health related to the app. But those teenagers weren't at this Consumer Electronics Conference, right, which brings professionals from all over the world to learn about different consumer electronics features for advertisers, right? That's an event that's for advertisers. That's not an event that's to get kids to download Snap. So it's really unrelated. And that's why the advertising that the state points to is both insufficient because it's isolated, and also insufficient because it's not tied to the alleged harms here. The alleged harms here are that kids are downloading this app, that kids are engaging in activities on this app that allegedly hurt their mental health. And we're going to hear in a few minutes that these activities that these kids are alleging, for example, body image issues, right? That's not something that Snap is doing in Nevada, that Snap has come to Nevada and promoted bad, body image. That's things that kids are exchanging with each other, just like they would on their phones or in the hallway at school, having to do with body image issues, bullying, things like that. Those aren't related to Snap's contacts in Nevada. And so that's the second problem. So for these reasons, Your Honor, we believe that the proper place for the state AG would be to sue in California, as I noted, other AGs have, and that this case should not even be in this court. But obviously we'll go on with our other arguments.
Before you do that, because as I sit here right now, I can't remember if it was tied to this argument or other arguments or both. But the idea of, oh, what's my train of thought now? Because something you just said it there at the end and I wanted to connect to. It'll come back to me. The other reason I'm a little distracted and unless I think my train of thought is, I'm right at the time frame where I need to transition my other duty that I have today related to search warrant review over to the secondary judge. And what I'd like to do is just step out briefly before we transition over to Ms. Blavin and check the queue so I can complete my duty and then I'll be right back in, okay?
Perfect.
All right, thank you.
Thank you so much, Your Honor.
Thank you, Your Honor. Jonathan Blavin from under Wilson on behalf of defendant Snap. As Ms. Davidson previewed, I'll be addressing two additional threshold reasons why the state's claims fail, even if the court were to find personal jurisdiction over Snap in this case. And those are that the state's claims are barred by Section 230 of the Communications Decency Act and are similarly barred by the First Amendment. So the state's allegations demonstrate what numerous courts have already recognized in holding near identical allegations barred by Section 230. And that is that the state's challenges to Snap's design choices and targeting of young users are inextricably linked to Snap's decisions regarding the publication of third-party content. And as the federal courts of appeal and numerous state courts have held, Section 230 should be construed broadly. The Force versus Facebook case from the Second Circuit held this, that's 934 F3rd 53, noted that the federal courts of appeal are in general agreement that the text of Section 230 C1 should be construed broadly in favor of immunity, and numerous courts, as cited in our papers, have held across the country that this immunity applies fully to the various types of claims asserted here, including product liability, negligence claims, claims brought by state attorneys general, as well under Deceptive Trade Practices Acts and other unfair competition claims.
Now, would you agree that there are also cases where that did not occur, where in fact the court determined that Section 230 did not apply to the state claims?
There are some cases in which courts have concluded that, and I'm happy to address those at any point in time, and it really depends, and I'll discuss this in more detail today, on what is challenged in the complaint, what the allegations are, what are the alleged duties that the platform has violated.
Okay.
And that's why it'll.
I remember my question, so you can answer it, is obviously we have case law that is related to other platforms, not just Snap. When you refer to these cases, from what I've seen, the bulk of them, if not all of them, are other platforms, not necessarily Snap platforms, at least the ones that I have most detailed connected to, shall we say. So what I was going to ask as far as the jurisdiction complaint aspect of the complaint or other components such as this is, does it matter that there are differences? And if it does, what are those differences between Snap and Snapchat and, for instance, TikTok or other platforms? So.
It's a great question, Your Honor, and I will say, as Ms. Davidson noted, that Snapchat is different than the other social media platforms in the sense that it opens to a camera and is really intended to facilitate user-to-user communication. So messaging functionality is at the core of Snapchat. That is different than some of the other platforms such as Instagram or TikTok, which open up to what has been described as an endless scroll of recommended content to the user.
So to the extent that that matters, like I said, to the extent that there's something either in the cases where Section 230 was found not to apply, or to the extent that it matters to your particular argument, make sure you fold that in, that discussion.
Absolutely. And what I would say is, where courts have applied Section 230 immunity to claims against Meta or Instagram or to other platforms, I think the underlying allegations in those cases match and mirror the allegations here made as to Snapchat, but to the extent there are material differences, I would be sure to note that to the court. Now, the state really doesn't dispute that two of the three prongs of Section 230 are met, and that is that Snap is an interactive computer service, and that the content that's published on Snapchat is created by third-party users of the app. Really, the only question is whether the state's allegations target Snap's role as a publisher of third-party content. And what the Ninth Circuit stated in the Barnes versus Yahoo case, this is at 570 F. 3rd, 1096, quote, what matters is not the name of the cause of action, but whether the cause of action, quote, inherently requires the court to treat the defendant as the publisher or speaker of content provided by another. So for purposes of today's argument on Section 230, it's not so much going to be a cause of action by cause of action discussion. It's going to be look at the underlying allegations in the complaint that the state is challenging, which form the basis of its theory of liability. And that's exactly what...
And I do have the complaint here, obviously, so if you wish to point to anything in particular, please do so, otherwise.
Yeah, and I'll be making frequent references today to allegations in the complaint, of course, understanding the standard on the motion to dismiss, that you take the allegations alleged as true for purposes of deciding the issues.
To the extent that they're factual and not, legal conclusions,
Of
but
course,
yes.
of course. And yeah, the court is not writing on a blank slate here. There are two proceedings, one, a federal multi-district litigation pending in the Northern District of California, in which there are private personal injury plaintiffs, school district plaintiffs that are alleging substantially similar claims. There was also a California state court proceeding in LA, a coordinated proceeding, in which the court is considering very similar claims. And what both of those courts did, which I think is the proper analysis, is to focus on what the actual allegations are in terms of the conduct which forms the basis of the claims. What the federal MDL court stated, for example, and this is, I believe there's only a Westlaw site available at this point, but it's at 2023 WL 7524912, and for purposes of going forward, I'll just be describing the MDL court's decision, but that's the site. The court said Section 230 applies when imposing liability for a claim would, quote, require defendants to change how they publish third-party content. The JCCP court, again, considering very similar allegations stated in its order, and this is the 5255 JCCP proceeding. We attached this order as Exhibit 1 to our reply brief on the motion. It's the court's decision on the motion to strike. It hadn't come out at the time we filed the motion. The court, when applying Section 230, said the defendant's decisions about how to publish and disseminate content are protected by Section 230, and that's consistent with a broad range of federal court of appeal, district court, and state court of appeal decisions which have applied Section 230. So in considering the analysis here, whether the claims are based on a particular design or feature doesn't end the inquiry. You need to look at what the allegations are in terms of determining whether Section 230 was applied. And as an example, I would urge the court to take a look at the recent Ninth Circuit decision that we submitted as supplemental authority. It came out after the conclusion of briefing on the reply brief. This is the Bride versus YOLO case. There isn't a Federal Register site yet, but it's at 2024 WL 3894341. And the Ninth Circuit held in that case that Section 230 barred product liability and failure to warn claims premised on the, quote, general possibility of harm to minors from the design of the defendant's anonymous messaging functionality. So there the plaintiffs were saying, we're challenging that particular feature, that it allows messaging to be anonymous because we think that creates a general risk of harm to minors because it can facilitate bullying, harassment, etc. on the app. And the Ninth Circuit ultimately held that Section 230 required dismissal of those claims because they went to the question of, are you trying to regulate how the defendant disseminates and publishes third-party content, and ultimately does your claim go back to that published third-party content, which again is harassing and bullying messages. And here the state's claims fall within the scope of Section 230 immunity because they are based on Snap's decisions about how much third-party content to publish it, how to arrange and present that content, and how long to publish it on Snapchat. And the state's really the only sole argument that you see in their opposition, or at least it's the primary argument as well, our complaint doesn't refer to any specific type of third-party content. We're just making general allegations about the design of the platform, but we're not pointing to any specific particular piece of content. Well, I would urge Your Honor to take a look at slide 6 in the demonstratives, which includes numerous allegations in the complaint that reference the publication of third-party content. You can see there's lots and lots of information in there. Normally, I wouldn't create a slide for the court with that much detail, but I thought it would be important to emphasize how much they are pointing to the publication of third-party content and particular types of content. So just as an example, in paragraph 170 of the complaint, they allege that Snap uses, quote, algorithms to deliver content, and they specifically point to the fact that those algorithms deliver, quote, extreme content, such as pro-anorexia posts and videos. In paragraph 186, they're generally challenging the fact that Snap facilitates various third-party messaging, communications on the platform. They note that this results in, quote, sexual interactions between minors and adults and pornography exposure, again, third-party content. In paragraph 150 of the complaint, as an example again, they fault Snap's Family Center as not preventing, quote, cyberbullying, sexting, sexual harassment, hate speech. So there are plenty of references in the complaint to particular types of third-party content. But again, even if the state had managed to avoid any particular reference to third-party content, it's undeniably clear that the state's allegations challenge how Snapchat publishes third-party content and with reference to that third-party content. As the MDL, the JCCP courts held, that falls within the scope of Section 230 immunity. So
Now, I just want to interrupt here because
Yes.
obviously in looking at the complaint, but also in looking at the state's response with that additional authority, specifically speaking to a state of pride versus YOLO technologies, the argument was made here that, this ultimately, the gravamen of this complaint is to seek to hold Snap liable for its own decisions about how its features are designed to provide content or how they would affect and profit again from how the information goes out to users in the state of Nevada, distinguishing it in their argument from third-party content specifically. And so, there can be allegations that refer to third-party content because obviously depending on if there are algorithms or if there are, as alleged, mechanisms, design, whatever is the appropriate way to use the terminology to push that content to certain parties because of either where they live or what they have previously searched for or whatever. Isn't that where it comes in that it's not about the third party, it's about Snap's own decision making? Because what I'm trying to get at here, and if you haven't noticed, the flavor of my typical questions are, okay, some of the things you're saying may be true, but other things may be true also. And it's not helpful in the court's opinion to just focus on the arguments that are beneficial to your side without then highlighting and, if you can, knocking down the arguments to the other side. So yes, there are multiple allegations that are listed here from the complaint that talk about third-party content. But isn't the gravamen of the complaint how Snap uses that, what algorithms they use and how they use them to ultimately, highlight their decision-making as to how its features are employed, how it makes its profit, et cetera? Isn't that?
That is what they are arguing and alleging. What I would say, Your Honor, is when you look at those choices that they're referencing, those design elements, what those refer back to are Snap's publishing decisions regarding third-party content. And what the courts have held is, yes, Snap has designed its platform in a certain way, but the allegations that they're challenging fall within the rubric of publication and a publishing decision. The Ninth Circuit has referred to this as an editorial decision by the platform. So those are decisions in terms of how the platform is designed, but because they fall within the scope of a publication decision, they fall within Section 230. And that's exactly the argument that the plaintiffs made in the Bride versus YOLO case. We're challenging a decision by the YOLO app to have anonymous messaging functionality, to make the functioning anonymous. That's what we're challenging. That was the platform's decision. to design the app in that way, which we say creates all of these harms. What the Ninth Circuit said is, that may be so, but that was a publication decision by the app and it falls within the scope of section 230. So to get a little bit more granular, I'd like to go through with the court's indulgence the specific features and functionalities they challenge and why they fall within well-settled case law in terms of what constitutes a publication decision protected by section 230.
Okay.
So for example, the state alleges that Snap facilitates harmful messages and conduct by third parties. Again, Snap opens to a camera, that is sort of its core functionality is messaging. And again, the complaint is filled with allegations that third parties have misused Snapchat in the context of that messaging functionality. Paragraph 186 to 187 of the complaint alleges, again, that Snap facilitates sextortion and the spreading, quote, of sexually explicit photos. Paragraph 86 alleges that Snap transmits threats through the messaging. Paragraphs 139 and 150 reference cyberbullying. Paragraph 86 references stalking. Paragraph 139, for example, references racist items. So this is really, Your Honor, low-hanging fruit, so to speak, because this is the prototypical type of activity which section 230 would apply to. The Ninth Circuit made that clear in the Kinsey versus Yelp case, 836 F3rd at page 1266. Claims based on users communicating with other, messages posted, including via private messaging, that's all within the heartland of section 230 immunity. I think that's an easy one for your Honor to say, yes, those types of alleged harms fall within the scope of section 230. The state also, and just another case from the District of Nevada, the Blotcher versus MindGeek case, this is a District of Nevada case of 2023, WL 5054696. The District of Nevada, applying well-settled Ninth Circuit law, said claims that, quote, can be boiled down to deciding whether to exclude material that third parties seek to post online, that's protected by section 230. That's what these allegations go to.
And just while we're here, because this is again what I wanted to have the record be clear about, is obviously if the court doesn't have specific personal jurisdiction, that affects all 6 claims. Do your arguments affect all 6 claims, or just some of those claims? Because that's not clear to me.
So what I would say, Your Honor, is the vast majority of the allegations in the complaints, and really that go to the core substantive claims, reference protected publishing activity. I don't think the state has actually alleged any type of claim that could be survived independent of all of the types of functionality that I'm going to go through as protected by section 230. In complete candor with the court, the limited allegations in the complaint, which I would agree with the state could fall outside the scope of section 230, are their particular affirmative misrepresentation claims. So these go to allegations that Snap said X, Y, or Z about its platform. And these are affirmative misrepresentation claims because that's Snap's own content, that's Snap saying it. It's not really a publication decision. So I would say for purposes of the argument today, I don't believe that affirmative misrepresentation claims would necessarily fall within the scope of section 230, though as Ms. Davidson will address, I don't think those claims are sufficiently pled to survive anyway under the substantive state law. They're very generic, puffery type statements on Snapchat. I don't think they apply the cause of action there. But with candor, with Your Honor, those claims could potentially escape section 230. Now I want to be very clear. To the extent the claim is an omission claim, that Snap didn't say X, Y, or Z about its platform, that's really a failure to warn claim. And the courts have consistently held that if the allegation is you failed to warn about a protected publishing activity, harmful third-party content, etc., that would ordinarily fall within the scope of section 230, that would be barred. The Ninth Circuit has just held that in the Bride versus YOLO case. The plaintiffs there had a failure to warn claim, and the court said the fact that you described this as a failure to warn, that the YOLO Act didn't warn users about the dangers of its platform with respect to anonymous messaging functionality, because you're really complaining about the underlying publishing activity, the failure to warn claim is also barred by section 230. Numerous other courts have held the same. I'll briefly reference those later, but I think everything else, the core substantive claims they're making are protected publishing activity, and there can't be liability for those underlying claims. So for example, the state also targets Snap's publication of content through algorithmic recommendations. This is at paragraph 170 of the complaint. They allege, for example, that platforms like Snap, quote, use algorithms to deliver content related to topics and themes that the platform believes will maximize a user's time spent on the platform. And again, they refer to specific content, extreme content, pro-anorexia types of content. And the overwhelming consensus of the courts, Your Honor, is that Section 230 prohibits liability based on the algorithmic recommendation of content. This is exactly what the Ninth Circuit held in the Dyroff versus Ultimate Software Group case cited in our papers. It's at 934 F3rd 1093. The Ninth Circuit said that algorithms or other features used to recommend content to users are publishing, quote, tools meant to facilitate the communication and content of others, and those claims are barred by Section 230, challenging those features. The federal MDL court applying Dyroff, considering near identical allegations, held in its order at page 13, that, quote, the use of algorithms to determine whether, when, and to whom to publish third-party content. Again, this goes to Your Honor's question. This is a decision by the platform about how to design its website, which content to recommend. The MDL court held under Dyroff that is conduct that is, quote, essential to publishing and is protected by Section 230. The JCCP court held the same in its motion to strike order, holding that, quote, recommendations of content are protected by Section 230. Other courts have held the same, including most recently, quite recently, the Wozniak versus YouTube case, California Court of Appeal case at 100 Cal App 5th 893. The court held that, quote, a website's use of content-neutral algorithms without more does not expose it to liability for content posted by a third party. The Force versus Facebook case from the Second Circuit, 934 F3rd 53, held the same with respect to algorithms, noting that the publisher of third-party information, when it uses tools such as algorithms that are designed to match that information with the consumer's interest, so the consumer's interest in the content, it's delivered to them. The court held that that is publishing content protected by Section 230. The state also points to Snap's ephemeral design. This is the fact that snaps on Snapchat disappear after a period of time. So really challenging how long Snap decides to publish particular content. And again, courts have consistently held that a platform's decisions about how long to publish content, to remove that content after a period of time, is also protected publishing activity under Section 230. The MDL court held this, again, at pages, I believe, 13 to 15 of its order, noting that claims based on the decision to, quote, limit content to short-form and ephemeral content are barred by Section 230. The JCCP court, again, this is the court that the state initially relied upon in its opposition to the motion to dismiss. In its motion to strike order, the court noted that while private and ephemeral content are, quote, allegedly dangerous for minors, they, in fact, are defendants' decisions about how to publish and disseminate content, and claims challenging those decisions are barred by Section 230. The LW versus Snap case from the Central District of California, this is at 675 F sub 3rd at 1097 to 1098, held that Section 230 barred claims focused on Snapchat's, quote, ephemeral design features that allegedly made the app more dangerous to minors who were potentially vulnerable to a sextortion scheme. So the courts have unanimously, in considering the ephemerality design, said that that is a protected publishing activity for which the platform has immunity under Section 230. The state also challenges SnapMap. This is a feature which, quoting the state's complaint, and this is at paragraphs 139 to 145, quote, allows users to share their location, with friends and family. And the state specifically ties SnapMap to particular third-party content harms. So for example, in paragraph 139, the state says that SnapMap puts users at risk of cyberbullying, for example. The state also alleges in paragraph 141 that SnapMap can be abused by, quote, dealers on Snapchat who will tag a location and essentially post up a menu of what they're selling. So again, it's users sharing their location information, which itself is third-party content. And they're specifically noting instances of users abusing the tool to engage in cyberbullying, to engage in the sale of drugs, but again, that's all third-party content. And again, numerous courts have held that the sharing of geolocation information is a protected publishing activity. And this is the users deciding to share their information under the state's own allegations. The federal MDL court held that, quote, and this is at page 13, limiting publication of geolocation data provided by users inherently targets the publishing of third-party content and would require defendants to refrain from publishing such content. The Doe versus Grinder case from the Central District of California, cited in our papers. I apologize, I don't have the Westlaw site in front of me, but I assure you it is cited in our papers. It's a Central District case from December 28, 2023. The court noted that, quote, geolocation data is third-party content generated by the user, and publishing it is a protected publisher function. The Herrick versus Grinder case from the Second Circuit, at 765 F Appendix 586, held the same with respect to the Grinder app's geolocation function. The Marshall's Locksmith Service Inc. case versus Google, it's a DC Circuit case from 2019. 925 F 3rd 1263 held the same with respect to Google's publishing of location information on a map, and said that is a protected publishing activity, and Google was immune from liability. Another functionality in the complaint is with respect to notifications. The state alleges that Snapchat's allegedly, quote, frequent alerts or notifications is wrongful, and that these notifications alert users about, quote, new messages from friends, new snaps from a friend, new stories added to a friend's profile, new memories created by a friend, and this is in paragraphs 129 through 133 of the complaint. But again, those are tools meant to facilitate the communication of users. The Dyaroff case from the Ninth Circuit specifically considered whether there could be a claim premised on providing a notification to a user of third-party content created, and what the Ninth Circuit held in that case is that notifications are, quote, tools meant to facilitate the communication of content in others, and there could not be liability for notifications because it's a publisher function. The MDL court at page 15 of its order held the same. The court said that section 230 bars notification claims premised on notifications, quote, made to alert users to third-party content. And again, that is exactly what the state is alleging here. The state also challenges endless feeds, what they describe as endless feeds. Feeds meant to show users content that go on, and there's additional recommendations. So the state notes in paragraphs 97 to 101 that this feature, quote, strategically and intermittently surfaces content that the platform predicts users will want to see. Well, one, that goes back to the Ninth Circuit's decision in Dyaroff, that providing an algorithmic recommendation to a user of particular content is a protected publisher function. That's exactly what's alleged here. You're matching the user's interest with content. And also the MDL court held, again, considering near identical allegations, that section 230 bars challenges to, quote, not providing a beginning and end to a user's feed. The state also makes allegations regarding age verification and parental controls.
So can I just ask
Yes.
a question? Only because I'm mindful of the time,
Yes.
and I know we have to complete your argument, we still have to give the state the opportunity to their argument, we have to conclude at 5, and I'm not carrying this over till tomorrow, just to be clear about
Yes.
that. So like, I understand, I've read the complaint many times, I've done my best to sort of get ahead. Are there any allegations by the state, I think you already answered this when I asked my question earlier, but are there any allegations by the state that you think, you know, even come close to falling outside of section 230? Because at this point, you know, you're going through each of the types of the allegations, geolocation, the ephemeral stuff. I don't know that we need to do that. I think that's in your brief. I think I understand that. I don't know that we need to get into this kind of detail at this stage, but I guess I'm just trying to interrupt here to see how many more of these examples you want to go through, or are there any that are close calls that you want to maybe highlight versus going through each one by one?
Yeah, and I'm almost done, but I hear your honor, and I can streamline it very much. I'll point out to ones which come closer to the line.
Any ones that you think are, you know, going to be the subject of the argument or otherwise, or again, it's in the brief, I get it. I just, you know, I have to be mindful. I want to give every opportunity, as I said, the fullness of the argument, but I don't need to go one by one, I don't think, based on all of the various allegations and all of the reasons why you still think, you know, 230 applies, I get it. And if you have particular cases to highlight, I get it. Go ahead and finish, but if you can somewhat streamline it, I'd appreciate it.
Yes, of course, and I apologize, Your Honor. if it's
Not at all,
not
because we still have to go through the
Yeah.
claims themselves.
No, and I understand that.
That's why I asked the question initially of, are there any claims that you think, and if I heard you correctly, you think no, based on what they are alleging to be the activities of Snapchat, Snap's efforts, that you think that they all ultimately fall because of the Section 230, but there could be considered potentially in either claims 1 and 2, which are the Deceptive Trade Practice Act state statute violations. Perhaps there is something where if there's an allegation of intentional, type of activity that in that end, perhaps that would necessarily still require, further argument or fall outside. But your position is it all falls within 230, all the claims fail. And, again, I get that. I just then to go through them one by one, I think is a use of our time that maybe isn't as beneficial.
Of course, Your Honor, and I guess the other thing I would say is, even to the extent Your Honor thought that perhaps 1 or 2 of the allegations fell outside the scope of Section 230, but would support the underlying cause of action, it would be extremely helpful at this point in the litigation to get guidance from the court as to what's in and what's out. That's what both the MDL court did and the JCCP court did, because that will provide the parties with crucial guidance, for example, on the scope of discovery, what's permissible and what's not. So I think that would be a helpful exercise if Your Honor was willing to do that. Just very, very quickly, age verification and parental controls, they then tie those mechanisms to the publication of third-party content as noted with respect to paragraph 150. They're specifically saying that if the failures of Snap's age verification and parental controls lead to cyberbullying and sexting, numerous courts, including the JCCP court, held that those types of allegations are barred by 230. With respect to rewards, what I would say in the rewards, Your Honor, and this is probably one of the more edge cases, for example, in terms of underlying content or conduct. They allege that these rewards are features that acknowledge, quote, milestones and metrics in communications history. But I think that falls within what the Ninth Circuit describes in Kinsey versus Yelp at 836 F3rd at 1270, that you're reducing certain inputs from third parties into a single metric, that is publishing activity too, protected by Section 230. I would also note with respect to rewards that the MDL court held, correctly in our view, that rewards generally by a platform are protected speech under the First Amendment. So that's an independent ground to hold that rewards given to users, you can't impose liability based on that, at least under the First Amendment. Filters and other effects, I would say this could be a more challenging, or at least more edge case with respect to publishing activity. But what I would note, Your Honor, is that with respect to filters, what they're really alleging is that users used filters and then that other users saw that type of content that had a negative effect on them. So for example, they noted paragraph 169 and note 138 that children compared their appearance to others, including influencers who had used filtered photographs. So again, the harm underlying the claim is still premised on a user seeing another user use a filter. And I think that distinguishes the primary case that the plaintiffs rely upon in this regard, and that's the Lemon versus Snap case. They rely on this case broadly. It's a Ninth Circuit case, and it involves something on Snapchat called the speed filter, and the allegations were that it purportedly encouraged users to drive too fast. It would show their real-time speed while the filter was on, and that the harm, which was a car accident, occurred regardless of whether they posted any content or even viewed any third-party content. So what the Ninth Circuit said is in that case, the plaintiffs had alleged a harm, quote, independent of any danger related to the publication or transmission of any third-party content. The Ninth Circuit specifically went on to note, in footnote 4 of that decision, that a claim premised on publishing third-party content, such as viewing a high-speed snap, which then encouraged you to speed, that would fall within the scope of Section 230. And I think what slide 6 demonstrates here is all of these allegations in the complaint are premised upon publication of third-party content. They're not alleging that there was some feature and functionality apart from publishing that content to users which caused the harm. So, as multiple courts have held, including the federal MDL court and the JCCP court, the Lemon decision is distinguishable on those grounds because ultimately the harm there would have occurred regardless of publication of third-party content, whereas that's not the case here as to the state's underlying claims. I did address the failure to warrant claim, so I won't revisit that, and I'll be very brief on the First Amendment now.
Okay, and I just want to keep in mind as you do that, because we have to go back to the claims, if I can only give you until about 3:30 to wrap this up, because I need to give equal time to the state, and that may leave you with very little, if any, rebuttal.
Okay.
So use your time wisely.
I will go very quickly here on the First Amendment then.
Because again, my point is, I've read everything, and the reason I gave myself the grace at the beginning to come back on another day to announce the decision is so that I can then review everything again after oral argument. I do not need minutia detail argument, in my opinion, but I'm still gonna leave you to your best decision-making as to what you wanna put before the court.
Of course, Your Honor. And just to note very briefly on the First Amendment, as the Supreme Court recently confirmed in the Moody versus Net Choice case, online platforms put choices about what third-party speech to display and how to display it fall within the scope of the First Amendment. I think the decision you were referencing earlier, Your Honor, the Rays versus Utah case from the federal district court in Utah that we submitted as supplemental authority considered almost identical allegations in the context of a state statute. And this included mandatory age verification and parental control features.
But of course, that case, and I don't mean to, just sit at the 30,000-foot view and not get in the weeds here, but that is a case where the attack was as to the constitutionality of the statute. And the court then ultimately determined to enjoin its enforcement, at least temporarily, to determine some things. Is that not so differently postured from here that it really is not beneficial here? Because again, we are talking about how the allegations are set out. I understand fully all the arguments, I believe, still just wanting to gather the nuances of them. But in the end, saying you don't have jurisdiction, okay, saying, 230, section 230 of the act precludes. Now when we get into First Amendment, now when we get into factual bases of what the speech is and the circumstances, is that really something that's ripe and appropriate for dismissal? And, the other cases that you, at least supplemental authority related to, I obviously have cases that you cited that were not the supplemental ones, but these are ones that are postured very, very differently, where it's not dismissal, it's the cases potentially going forward, but the statute was being attacked for its constitutionality.
That's correct, Your Honor. And what I would note is that numerous courts have applied the First Amendment as well as a defense to tort claims, including in the context of a motion to dismiss. And even the MDL court, which again held that certain features were protected by the First Amendment, noted in dismissing those claims that, this is at page 17, the free speech clause of the First Amendment can serve as a defense in state tort suits. The James versus Meow Media case from the Sixth Circuit, cited in our papers, this is at 300 F3rd 683, specifically noted that if anything, the specter of tort liability, which can be so amorphous and broad, provides a greater reason why the court should provide, scrutinize allegations to see whether they are consistent with the First Amendment at the motion to dismiss stage 2. So while Your Honor is absolutely correct that these are cases challenging statutory provisions, which are sort of seeking to regulate the very same types of activities that the state's complaint is doing, nonetheless, the court can and should analyze whether those allegations are consistent with the First Amendment. And I think what these recent decisions, again involving statutes, demonstrate, such as the Rays case, such as the Net Choice versus Bonte case from the Ninth Circuit, which we submitted supplemental authority on, is that the courts have had no hesitancy to say that trying to impose that type of duty on a platform would infringe upon its First Amendment rights, and those are the same duties that the state seeks to assert here.
I see.
And I'll leave it at that, Your Honor.
All right, thank you.
you.
And Ms. Davidson, as I understand it, you're gonna come back now and go through the individual claims.
Yes, Your Honor, I'll be speedy. I will talk speedily. I will
Well,
just be speedy.
Thank you for appreciating that nuance, because half the time when I say we need to have a little more alacrity, I just get people talk faster and say all the same things that they wanted to say rather than to sum up. And so I appreciate you recognizing that distinction.
I will be succinct, but I will not torture the court for it.
Thank you.
So, Your Honor, Mr. Blavin made the point, Mr. Blavin made the point that Section 230 would not bar misrepresentation claims, and then he sort of previewed what I was going to be
Intentional, yeah.
talking about, which is that if you look at the complaint, and so we're starting with count 1 and DTP. I know you asked to do this by count, so we're starting with count 1 here.
Yeah.
And
Well,
if
the
you-
two counts, there's 2 Deceptive Trade Practice Act counts, and this is one of the 2.
Count 1 has to do with alleged deceptive acts, and count 2 has to do with alleged unlawful acts. I want to start on the alleged deceptive acts to follow up on what Mr. Blavin was saying, and I think it's important to actually see what are the quotes in the complaint that are allegedly deceptive. Because I think it's very telling, if you look at them, that these are either statements that are just plain true and can't be controverted. For example, the SNAP CEO, paragraph 194, saying that the app opens to a feed. I'm sorry, does not open to a feed, that the app opens instead to a camera, and as he puts it, your own experience to express yourself and share and connect with your friends.
And then following along here on page 11, or slide 11, if you're
So the,
demonstrative.
so
Go
the
ahead.
statements that are in the complaint are not affirmatively false statements, both because they're either factual, how does the app open? They're what I would call puffery or aspirational statements, like you're opening up into your own experience. That's obviously a matter of subjectivity. What does that mean? That's not an actionable falsehood in any way. Or they're aspirational statements. For example, plaintiffs cite the CEO of SNAP saying, unless businesses are proactively promoting health and well-being of their community, regulators are always going to be playing catch-up. That's not a statement that could be false in any way. And then there's another group of statements that are policy statements made by SNAP employees before Congress, and those are not actionable, both because they're very generalized statements, like part of living up to our mission has been building and maintaining trust. That's not something that can be proven true or false. And also because statements to Congress are immune from liability under the Noor-Pennington Doctrine. And if we look at slide 12, this is confession. This is the case that I found this weekend, and
I have it
I
highlighted.
apologize, it's in here even though not in our briefing. I thought this case was really, really on point here, because it's about a gaming organization that alleged all very similar types of alleged misrepresentations. They said, we have integrity. We have a deeply rooted culture of compliance that ensures upholding the highest standards of fairness and transparency. We must all hang together or we will hang separately. Caesar's Palace is the first to practice responsible gaming. These are exactly, like uncannily, suggesting perhaps that, company executives use similar types of language, but uncannily similar to comments like, we need to be promoting health and well-being in our community, and people should be allowed to express ourselves. We want to live up to our mission of maintaining trust. These are these sort of generalized, you can call them policy statements, you can call them puffery, but these statements can't be proven true or false. And if something can't be proven true or false because it's more of a generalized statement, then it's not deceptive under the Act. Let's move along, because I did promise to be succinct.
That's okay.
Count 2 is, as you noted, also the TPA. So I want to focus on the fact that the DTPA applies to the sale or lease of goods or services. So putting aside whether there's even an actionable statement for the first count 1, both count 1 and count 2 have a problem in that there's no sale or lease of goods or services here. As we talked about earlier, SNAP is downloaded for free on your phone, and there's no purchase, there's no payment. So this isn't really a transaction in the way that you would think of what the Deceptive Trade Practices Act is intended to address. And so that's the problem with count 2. Let's move on to count 24.
And these are then your product liability.
Correct. And I think there are 3 fundamental problems with these causes of action. The first is that despite scouring the Nevada revised statutes, I could not find any place indicating that the state AG has authority to bring these sorts of common law claims. For sure, the state AG has authority to bring claims under the Deceptive Trade Practices Act. The state AG has authority, if you look at revised statute 228.380, to enforce the equal credit opportunity law and all sorts of enumerated authorities. I have not found an enumerated authority suggesting that the state AG can bring a common law claim. And it's a particular concern here because when you think of a parent's patriot claim, it's really the state bringing something that people can't bring on their own. But here we do have, as Your Honor may know, two huge proceedings in California where individuals, often parents on behalf of their kids, have brought claims alleging mental health injuries. There are Nevadans who have brought claims alleging their own injuries. So this isn't a situation where the state AG is needed to vindicate any rights of Nevada citizens. That's the first problem. Second problem is very simple, which is a product liability case requires fundamentally a product. And as courts have held, 2 of them cited here, social media cases and Zienchik v. Snap, defendants' platforms are not static things. They are not tangible products. Snapchat is more like a service than a product. So there's no product here that's sold and purchased and can be held and can be sued over because this is really more like a service. So that's the second problem. Third problem is causation. So if you think about causation, there are 2 elements of it, as you know, but-for cause and proximate cause. And a plaintiff suing for product liability, easiest example is the brakes on my car didn't work. I got in an accident. I wouldn't have had the accident if it hadn't been for those brakes. And it doesn't matter in that case that maybe somebody else in front of you stopped short because the injury is very direct to your car and your brakes. What we have here is something so much more amorphous, right? And I think that's part of the problem with this whole litigation is that this is really, the AG's raising policy concerns. Teenagers in Nevada aren't sleeping enough. Teenagers in Nevada have bad body image. Teenagers in Nevada have problematic internet use. Kids are on their computers and their phones instead of going to school. These are like broad policy concerns that cannot be tied either through but-for causation or through proximate causation to SNAP's activities. It's just too remote from what we're alleged to have done wrong. And the Goodrich case from the Nevada Supreme Court makes the point that you have to be looking at, for proximate cause, foreseeable consequences with a reasonably close connection to the defendant's conduct.
I can see, and I'm just, sorry to interrupt here a little bit because I think this also, could come up in the negligence cause of action, but, at the end of the day, isn't this a situation where we are talking about something that's just not appropriate for dismissal? I understand on your other 2 points, if the AG doesn't have standing to bring these causes of action, so be it. If the AG, if the SNAP service is a service, not a product, situation. But when it comes to the proximate causation, where would there be any case law that would suggest that the court can decide as a matter of law on a motion to dismiss that there's no proximate cause? I mean, it's alleged. Does that not survive dismissal just by virtue of being alleged? And is that not a factual dispute that would be required to be accepted by the court? Factual statement, I'm sorry, that would be required to be accepted by the court?
So, Your Honor, I would say that there are some situations where the claim, even if you accepted all of plaintiff's allegations as true, right? It would still not be viable, and therefore, that is appropriate on a motion to dismiss, and I believe, and I just want to confirm before I say it, that the Snyder versus Delaney case that involved a tavern drinker and whether the tavern could be held liable, I believe that was on a dismissal. But I don't want to say that for sure, but I believe that case was dismissed. I think fundamentally, I would agree that most of the time, causation should be a summary judgment question. Because, right, the question is whether the facts satisfy causation. Here, what I'm saying is that the claims are so attenuated from any possible harm to someone that it's a matter of law that this is just, there has to be some point at which a claim is so attenuated that it really is a pleading issue and a motion to dismiss issue. So
And I think that does that also segue over to your negligence count
that
5?
covers negligence because we're running short on time. That's great time.
I mean, that does appear to be the argument, the standing argument is raised there as well, but that does appear to be the argument. And then last but not least, we do have the unjust enrichment.
And I can cover that in 10 seconds, which is by saying, maybe 30, that the Corday construction case from the Nevada Supreme Court makes clear that the person conferring the benefit must have a reasonable expectation of payment. So if the claim here is that teenagers conferred a benefit on SNAP by downloading it, then under Nevada law, for there to be unjust enrichment, there had to be a reasonable expectation of payment. And what I would say to this is that, and as I indicated earlier, I do tend to do a lot of product liability and mass court cases, and there is a tendency among plaintiffs to throw in the kitchen sink and list every cause of action. But sometimes the cause of action doesn't fit what's going on. And here, Your Honor, there just is no way to say that there is enrichment by the users to SNAP, right? To the extent SNAP gets enriched, that would perhaps be by the advertisers. But there's, right, and the advertisers have a commercial relationship with SNAP. But when children or teenagers or young adults download this app, they are not expecting to be paid for doing so. And so unjust enrichment just does not fit within this, the framework of what we're talking about here. And with that, I'll turn it over and hopefully we have 3 minutes reserved for rebuttal.
We should have some, we'll make sure that there's some time. I don't know how much time
Understood.
Mr. Jones and his colleagues intend to take, but I do have the demonstrative, and so that I don't forget, I'm gonna give it to the clerk. Okay, mine's clean too. I highlighted the 2 that were the new,
Oh, okay. So
newly presented, so can I switch and give you this one and I'll take your clean one? Yeah. There you go.
Thank you for your patience with us.
All right, no, absolutely, no thanks necessary.
Your
Mr.
Honor,
Jo-
I hate to say this, but in light of how long we've gone on, could we take a 5-minute break before?
Absolutely, anybody need to use the restroom, I'm for it.
It's so nice when a man asks. I always feel like it's always us who have to go.
I'm for it.
It was my idea.